A bitter online feud explodes into real-world violence, and now a popular YouTuber could face the death penalty. Two people, a husband and wife, were gunned down on the Las Vegas Strip right in front of the Bellagio fountains while live streaming. And now the man accused of pulling the trigger, known online as City Manny, could pay the ultimate price. Prosecutors say Manuel Ruiz opened fire 7 times and then tried to vanish into the crowd. Police say it's all caught on video, including the moment Ruiz allegedly advanced towards his rival with a gun in his hand. Now, the Clark County District Attorney says they'll pursue the harshest punishment possible: death. I'm Kennedi Walker, and I'll walk you through the details. This is Law and Crime.
Hello? Can you come over here real quick? Let's just face the wall right here. We're just going to detain you real quick, okay? You got any weapons on you or anything? No, sir. All right.
Together like you're clapping? So you can?
You could double cuff it if you want.
Yeah, I might have to. Shirt's caught up. I'm trying to make it a little bit more comfortable for you. So you don't have any weapons on you?
Control carefully on the floor. Sure, through. 41.
Body camera video captures the moment Manuel Ruiz is detained and placed in handcuffs. Ruiz, a popular YouTuber known online as City Manny, is charged with murdering 2 people in a shooting on the Las Vegas Strip. And now, prosecutors say they're seeking the death penalty. The Clark County District Attorney's Office filed a notice that if Ruiz is convicted, they will pursue a death sentence during the penalty phase of the trial. According to court documents, Ruiz allegedly fired 7 shots at Rodney and Tanisha Finley while the couple was live streaming near the Bellagio fountains on June 8th. New body camera footage also shows the moment officers arrived at the scene just minutes after gunfire erupted in a heavily crowded tourist area. Prosecutors say Ruiz knowingly created a great risk of death to more than one person, opening fire in a densely populated space. They say they'll rely on court documents, police reports, witness statements, video, and Ruiz's own words to prove it. Investigators and fellow content creators say Ruiz had an ongoing feud with Rodney Finley, known online as Finny the Legend. The two were locked in a bitter online rivalry, live streaming verbal attacks, trading jabs across platforms, and building digital followings on YouTube fueled by drama. Their dispute reportedly began over a copyright claim, but escalated into back and forths and personal threats.
Jerome, I'm out here searching for my baby. I went through every casino there is. I heard there's one of my biggest fans here in town. I was dying to see him. Dying to see him. What are we doing? Fuel bar tonight? Is that what we're doing? I'll be there. I'll be there. I can believe it. You come to my city and think I'm not gonna show up? You think I'm not gonna show up? I should have been the first one to be told. Right? Somebody should have sent me my invite. Mr. Marquez. That's right. We outside.
After the shooting, Ruiz allegedly fled the scene, ditching his shirt, hat, and gun, according to an arrest report. He allegedly took a rideshare, then walked to a friend's house where he eventually turned himself in. During questioning, Ruiz reportedly told detectives he acted in self-defense, claiming he believed the Finleys were armed. He told police Tanisha Finley was dancing in his face and that Rodney appeared to be reaching for his waistband, which he assumed meant a weapon. but police say no guns were found on or near the Finleys, and no weapons were seen in any of the live stream videos. Detectives showed Ruiz the footage, which, according to their report, clearly showed Manny advancing towards Finley while shooting. Ruiz allegedly claimed he had no idea the Finleys were live streaming and denied making threats before the shooting. Now, Ruiz faces 2 counts of murder, and if convicted, prosecutors say he could be sentenced to death. Look, I know I say this all the time, but truly covering these stories day in and day out, you realize things are a bit crazy out there. That's why I'm so excited to tell you about a product we here at Law&Crime created. The Law&Crime Safety Bracelet. This is a bracelet you can wear around your wrist or keep in your car or in your purse, and it includes multiple items that give you actual peace of mind. I'll show you what I mean. A whistle, which has a classic high pitch, great for drawing attention when it matters most. A compact flashlight that can be used to guide you in the dark or signal for assistance, and a seatbelt cutter you can use in case of a car emergency. Plus, a handy utility knife for multiple uses, and these are just to name a few. So right now you can go to truecrimegoods.com and use promo code SAFETY15 for 15% off. That's promo code SAFETY15 for 15% off. You can order your safety bracelet now and carry confidence everywhere you go. And here to break down this story with me is criminal defense attorney Josh Tomshek. Josh, thank you so much for coming on today.
My pleasure. Thanks for having me.
So let's just jump right in. I mean, what typically elevates a double murder case to one where prosecutors seek the death penalty? What are they likely seeing in this video that pushes it there?
Yeah, I think you kind of touched on that in the question itself, the fact that it's a double murder case. In the state of Nevada, we have what we call aggravating circumstances, or more commonly we refer to them in the practice as aggravators. They're enumerated things by statute that make a case eligible for the death penalty. Probably the one that is most likely to cause the state to file a notice of intent to seek the death penalty is a case where there's more than one homicide. So the case of a double murder is a prime example of a case that is eligible for the death penalty, where the death penalty is often filed.
Is the fact that this happened on a live stream, in front of thousands of people online, people in public, a factor in the decision to pursue capital punishment?
I don't think the fact that it was live streamed factors into the state's decision to seek capital punishment. From an evidentiary standpoint, it may make them more likely to file the notice of intent to seek the death penalty, because as a general premise, the state is more likely to file a case seeking the death penalty in a situation where they believe they are more likely to get a first-degree murder conviction. So cases with better evidence tend to be the types of cases where they would file a notice of intent to seek death.
And you said an important word there, intent. I know that is a huge word that prosecutors use when they are trying these types of cases. I mean, does intent shift when a killing happens mid live stream? Does it suggest performance or premeditation in the eyes of a jury?
I don't know. I think there's probably different ways to spin that. As a defense attorney, I could say, look, if this was premeditated, he wouldn't have done it on a live stream. That indicates that it wasn't planned out. But from a prosecutor's perspective, the fact that someone was live streaming an act doesn't take away their ability to argue that it's premeditated. In Nevada, we have the definition of premeditation, willfulness, and deliberation are all required for a first-degree premeditated murder, is what we call it. And our law says that that can happen as quickly as instantaneous thoughts of the mind. So the decision to go from shooting one person versus transitioning to shooting a second person is in and of itself something the state can argue as a factor in premeditation.
Now, this all began because of an alleged online rivalry. We know rivalries can be chaotic, but at what point do digital threats cross over into legal grounds for that premeditation that we were just talking about, or malice?
I think it certainly gives the state motive, something to argue that there's a motive for the crime to happen. The state doesn't have to prove motive, but they almost always present a full picture of the allegation, which normally involves a motive. People don't kill people unless they have a reason to do it. So things like a rivalry, talking trash back and forth, whether it's digital or in person, certainly gives rise to that reason that someone commits a violent act.
In cases like this, how much does the prosecutor need to show that the killing was fueled by more than a heat of the moment reaction, especially when self-defense is claimed? Because I know you just mentioned they don't have to prove the motive, but since Mr. Ruiz is allegedly claiming it was self-defense, how does that work?
Yeah, and I don't know enough about the facts of this case to know whether he's got a viable self-defense claim or not. Self-defense is an interesting thing because if he raises that, the state then has to prove that he did not act in self-defense. But our self-defense standard in Nevada is kind of an ordinary, everyday person one, what they would do in that circumstance. And if someone is acting under the belief that they are about to be severely injured or killed, and they take violent action in response to that, that's lawful. That's not a first-degree murder. That's a justifiable homicide. They would have to show, however, that there was in his mind at that time a real belief, even if it's a mistaken one, that he's about to be substantially injured or harmed. If the jury doesn't believe that an ordinary everyday person in those same circumstances would have or should have acted that way, then it's not a self-defense case, and it becomes much easier for the state to argue that it's a first-degree murder. Heat of passion is a different thing. A heat of passion killing in Nevada is what we call a voluntary manslaughter. A voluntary manslaughter crime is one where the killing's intentional, but there's a reason for it. You walk in on your spouse engaged in a sexual relationship with someone else. You find your neighbor harming one of your children. You intend to kill them in that circumstance, but there's some type of a provocation that gives rise to it.
And given that this entire shooting and the buildup to it was captured on camera, I'm just wondering, again, an attorney can argue anything, but I bet that makes things a lot more complicated because regardless of what, an argument may be, they have video proof right there. I mean, and just thinking of this in just a broader aspect, in 2025, are prosecutors treating live streams the way that they used to treat eyewitness testimony?
Yeah, I mean, it's a lot more difficult to argue things happened a factual way when they're depicted on video. So like in the old days, when an eyewitness says one thing, maybe you can cross-examine them with something that another eyewitness said. It doesn't really matter what the eyewitnesses say if it's depicted on video. The jury can see it for themselves. So it makes things a lot easier from an evidentiary standpoint, proving the crime happened. The question in this case isn't going to be who did it. It's going to be why it happened. And one of the interesting things about an online rivalry that builds over time is by definition, it probably can't be a heat of passion thing because it's building for so long. Heat of passion killings are something that happens real quick without time to deliberate and think on the course of action. But if the state's able to present evidence that there's trash talk going back and forth and there's a reason for that to build up, that takes away from the defense's ability to argue that it's a heat of passion killing.
Is there a danger that this becomes more trial by viral moment than trial by fact? I mean, how do you keep a jury from being swayed by emotion over evidence?
I don't really think that's a factor, especially with Las Vegas juries. You got to understand that almost everything that happens in Las Vegas is on videotape. I tell my clients that all the time. Like, don't tell a story that isn't true because you know it's going to be on video, especially things that happen on the strip and casino properties and high trafficked areas. There's going to be on video. And in this case, apparently there was someone there filming. That's just evidence. It's no different than any other evidence. The jury gets to see it. They get to consider it. The attorneys get to argue about what it is. And to the extent that the defendant may testify, he can talk about what was going on in his mind. Other individuals can talk about their state of minds at the time. But evidence is evidence.
Let's talk more about Mr. Ruiz's version of events. I mean, according to authorities, Ruiz claims he thought the Finleys were armed, but no weapon was found. In Nevada, how far does a self-defense claim stretch when the perceived threat is based on assumption?
So it has to be something real and tangible that you can point to. But the real question is, what's going on in his mind at that time? Does he have a real belief that he's about to be substantially harmed or killed? And it has to be from the perspective of what an ordinary person in that situation would do. So if he comes up with some story that is completely implausible and defies logic to what a normal person in that circumstance would see, think, or feel, he's probably not going to have a good self-defense claim. One of the interesting things about Nevada law is if he's acting under a good faith belief that he's really about to be injured or harmed, even if he's wrong, it can still be a self-defense claim. An example, if someone breaks into my home and they pull out an object and I believe that it's a gun and I shoot them and it turns out it was a cell phone, I'm acting under those circumstances, that limited version of events, in a way that's reasonable. Most people would be able to say or articulate that factual scenario and say, look, I need to behave this way. I need to use force or violence. Otherwise, I'm going to be dead. And even if I'm wrong about the presence of a gun, still qualifies as self-defense. He can make that claim. The jury's ultimately going to have to decide what he was really thinking and if it's reasonable.
Could the fact that Ruiz approached them rather than retreating completely undercut his defense?
Yeah, so in Nevada, for a self-defense claim to fly, you can't be the initial aggressor. So if he approaches the situation and starts the confrontation, it's not a viable self-defense claim. If he approaches them and talks, like, remove Mr. Ruiz from this circumstance, and I can envision a different one where I come up to you, for instance, and I'm just trying to have a conversation with you, and all of a sudden you threaten me and I believe that you're going to shoot and kill me, I could probably make a self-defense claim in that factual scenario. But if he confronted them in anger or threatened them, he can't really say he's acting in perfect self-defense or a justifiable homicide in this circumstance because he's the initial aggressor.
Of course, anything can happen, and I'm sure you have seen or tried a lot of cases where it seems to be leaning one way, it ends up to go in another one. But what we were just discussing right here, just about self-defense, him, allegedly approaching the suspect, approaching the victims not having a weapon, according to police. This seems pretty open and shut. What do you think?
Well, we don't know. I mean, I don't know enough about the facts of the case. I haven't seen the videos in detail. I've just seen what's been portrayed in general news reports. I haven't read any statements. I don't know if there's threats involving a weapon previously and I don't know if this applies to this case or not, but let's envision a scenario where there's a digital social media argument going on back and forth, a rivalry over a period of time. And during the course of that, one party sends a picture of a firearm or says, next time I see you, I'm going to shoot you, or something like that. And then the next time they see them, that person who ends up responding to it with deadly force may have a claim. Look, he threatened me before. He had a weapon. I've seen him with it in person before. I knew there was the potential that he could pull out a weapon and shoot me. Those things all could lead to a self-defense claim, but I don't know enough factually about this case to know if that applies or not.
But let's say hypothetically that is the case, right? Then couldn't you still argue, well, then if you saw them in the middle of the street, why didn't you turn the other way? Why didn't you call for help? Why did you allegedly approach them with a weapon?
Sure. In Nevada, people don't have a duty to retreat. He wouldn't have to run away. But look, the facts of this case are going to bear out ultimately what the arguments are from both sides. I'm sure that the lawyers on each side will have differing perspectives of things. I know the attorneys involved in this case. They're very experienced. They're very talented. They're certainly the defense attorneys are going to do the best by their client, and certainly the prosecution is going to present the best case that they can. Obviously, the prosecution feels strong about their case because they filed the notice of intent to seek the death penalty. What the jury ultimately believes is going to be dictated by what the evidence is at trial.
Well, let's talk more about the jury. How hard will it be to find an unbiased jury when the footage has already gone viral and both men had large following?
Yeah, so one of the things that the jury selection process in Nevada in a capital case does is talk about media attention. Have you seen this case in the media? Certainly people that are followers of either of these individuals on social media aren't going to be allowed to be on the jury. There's enough people in our jury pool where they'll be able to find individuals that don't follow them on YouTube or Instagram or whatever the case may be. People that have seen extensive news reports related to this and seen the video. The attorneys in the court will have an opportunity to flush that out to determine if they can still be fair. Our vetting process in a case where the state is seeking capital punishment is much higher than one in which they don't. So we have to what we call death qualify a jury. So everybody that's on that jury will fill out a questionnaire. They'll be asked questions about the coverage of the case. They'll be asked questions about their feelings about the case. They'll be asked questions about their feelings about the death penalty. And both sides will have ample opportunity to ask them questions. It would take a lot to sneak past that process and wind up on a jury if you had a predisposition towards one side or the other.
Right. I mean, that makes sense. Just because I was wondering, just given his following, if that sort of made him like a public figure in a way, or even a perceived instigator.
Yeah, maybe, but those people are likely going to be precluded from getting anywhere near the jury. The court's going to want people that can be fair, impartial, and balanced. They're going to have to answer questions both in writing and in person in an open courtroom, all under oath. So the fact that someone's a public figure, that's nothing new in Nevada. We've had many cases in Las Vegas where people are known in the community and face criminal charges. So the court is very well equipped to deal with that, and the attorneys know exactly how to ask those questions and flesh that out.
Do you expect this case to go to trial, or could the death penalty threat be used as leverage for a plea deal?
Yeah, I can't really say. I mean, from a statistical perspective, a very small percent of felony cases filed in Clark County wind up in a jury trial. It's a very low number. Of those that go to trial, they tend to be ones where the stakes are substantially higher. Now, if Mr. Ruiz came to the state and said, look, I'm willing to plead guilty to 2 counts of first-degree murder if you take the death penalty off the table, I can't tell you that the state would agree to that, but I can tell you that's something they would strongly consider. There's not really a reason to go to trial at that point when he's willing to accept responsibility and take, for instance, a life sentence. But I don't know if that's in the cards. I don't know the state's position. I'm not involved in the case personally. I don't know anything about Mr. Ruiz's desire to plead or to accept responsibility. And I don't know anything about the state's desire to see it through to trial. Ultimately, that's the state's decision whether to resolve the case. They would have to make an offer. He can't be sentenced to death by way of plea. So theoretically, he could walk into court and plead guilty, and the state could still take him to a penalty phase and seek the death penalty in front of a jury. But I think that would be unlikely should he want to plead.
And tell me more just about that with the death penalty. Would it have to be unanimous in regard to that, or is it just the majority? How does that work?
Yeah, so as our United States Supreme Court has often said in published decisions, death is different. So the evaluation of a death penalty case is different, both in terms of what allows it to be eligible for death penalty and then the procedure that goes into it. So in Nevada, when someone is accused of a capital offense, one that's eligible for the death penalty, and the state is seeking the death penalty, if it goes to trial, that trial happens in 2 pieces. We call them the trial phase, is the initial phase of the trial. We used to refer to it as the guilt phase. That's where they determine if that person is guilty of first-degree murder. If at the trial phase, the jury comes back with at least one unanimous verdict for first-degree murder, they would then proceed into a penalty phase. If the jury came back with 2 counts of second-degree murder, which would be their right to do at a trial phase, it would never go to a penalty phase because he would no longer be eligible for the death penalty. But if a jury finds him guilty of first-degree murder, it goes into the penalty phase. And in the penalty phase, the state presents their aggravating evidence, the evidence that makes him eligible for the death penalty. The jury has to agree on that aggravating evidence beyond a reasonable doubt, the same as they would in a trial to convict someone. And that does have to be unanimous. However, once that evidence is presented, the defense has an opportunity to present what we call mitigation evidence or mitigators. And that can be anything. They do not have to be unanimous in their finding of mitigating evidence. And no jury ever has to give the death penalty, even if they believe the state has proven the case beyond a reasonable doubt, even if they believe that the state's proven the aggravating circumstances at a penalty phase, and even if only one person believes there's a mitigating factor, they can still not impose the death penalty. That's their right.
Well, this is a case that we will be following closely. Josh, thank you so much for coming on today.
My pleasure. Have a wonderful day.
Manuel Ruiz is being held without bail in the Clark County Detention Center. For Law and Crime, I'm Kennedi Walker.